Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I am the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Denise Puente, a Louisiana construction lien law expert. Today's webinar topic is what happens after I record my lien? How do I get paid? So without further ado, I'd like to introduce the fabulous Denise Puente.
Jessie, thank you so much for that introduction. For those of you that don't know me, I, as Jessie said, have been practicing law in Louisiana for more than 30 years, and my entire practice is dedicated to construction and surety work. So I've represented everything from owners, developers, contractors, subcontractors, design professionals. So I should be able to give you a good range of information regarding what happens after you record a lien from the different perspectives. And I'll be more than glad to answer any questions that you may have at the end of the seminar. Jessie, I think there's a chat box that you can type your questions into, and then she will read them to me at the end of the seminar. All right, next slide, please. I think it's important before we get started to discuss first the difference between public and private jobs, because that makes a difference with regards to things such as lien filing periods, what can be done when you prepare the lien to make sure that you're protecting your rights. I'm not going to go over all the specifics regarding liens because we've done those type of discussions before, and this is going to focus more on what happens when you file the lien. But I do think it's important to go over the lien recording deadlines, lien waivers, and what you want to look for when you're signing these with your monthly pay applications, because you don't want to waive certain rights that may affect your ability to enforce the lien later on in the process. We're also going to look at what happens when you bond out liens and how that affects your rights, and who then becomes liable for any amounts that may be owed to you for work performed or materials supplied on a project. And then we'll get into filing suit, things you need to look for when you're going to file suit, what your potential avenues of recovery are when you file the suit, and then we can have whatever questions that you may have. Next slide, please. The distinction between private and public works. Public works project is you look at the owner to determine whether or not a job is a public job or a private job. So things like the state of Louisiana, specific state departments such as Department of Transportation and Development, maybe facility planning and control, particular subdivisions or sub-political entities such as the city of New Orleans, parishes such as the parish of Jefferson. You may, St. Tammany Parish may put out a project for bid. That would be considered a public works project. Same thing if there's a city parish council. We can also look at things like school boards, all the way down to local entities that are all public bodies. That would be considered a public works project. Next slide. Then we're going to look at private works projects. And you think, well, that's pretty easy. That's things like hotels or apartment buildings or condominium projects. But sometimes people get thrown off because they think that something is a public project because there's state money involved or federal money involved. That is not necessarily the case. What you're looking at to determine whether something is public or private primarily is who is the owner on the project. So sometimes we see, like one of the examples I give here is the UNO Alumni Foundation. They once built a dormitory building. And so you may think, well, that's a UNO dormitory, that's a public job. Well, no, even though it's on the campus of UNO, the building itself is a privately owned building. The same thing, sometimes we read in the paper that there's some big hotel or condominium project that is qualified for certain tax credits. And so we may think, oh, that must be a public job, so let me follow the lien rules for public projects, when in fact that's not correct. It's going to be a private project. And as I mentioned, it's important to know the distinction from the beginning, because it's definitely going to affect how are you going to file suit, what it is that you're going to lien, and what notices, et cetera, are required when you file those liens. Next slide, please. Let's go over some basic lien recording deadlines. These are important. On Public Works Act projects, it's pretty straightforward. It's always 45 days after the recordation of either the acceptance of the prime contract or the prime contractor is terminated, what we call a notice of termination. And so, unlike on a federal project under the Miller Act, where the lien periods are the times that you make your claim against a bonding company on a federal project, those run from when you personally finished your work on that project. But in Louisiana, on public jobs, what we look at is the overall project completion. So whether you are the pile driver at the beginning of the job or you are the landscaper at the end of the job, the time period is the same. It's 45 days after the acceptance or the termination of that contract. And it's important to remember that on public jobs, there's no such thing as liening the building. So in other words, you can't lien City Hall. That is why on all public projects, the general contractor is required to provide a payment and a performance bond. The payment bond is what protects those individuals or those companies, such as subcontractors and suppliers, that actually provide labor materials to a project. It guarantees that they will be paid, assuming that they follow certain rules that are set forth in the statutes. Performance bond is more for the protection of the owner to make sure that the project is complete. In some instances, if you don't file a lien and you don't file it timely, then you've lost your claim against the bonding company. Remember, you always have a claim against the company with which you contracted with. You have a breach of contract claim. So if you're a subcontractor, you will definitely have a breach of contract claim against the company right above you in your contract, but you may not have a claim against the bonding company for the general contractor if you didn't properly follow the procedures. Next slide, please. Okay, the Private Works Act, just my thing I always like to remind people of if you are the general contractor. You have absolutely got to file a notice of contract before the work commences on a project, before the on-site work commences. For any contract that the value is over it's $100,000 or greater. It used to be that there was some exceptions that we would say, well, he wasn't really acting as a general contractor for this part of the work. It was really just self-performing work, so then they'd be allowed to file a lien. Well, a couple of years ago, the legislature closed that loophole. So now it's very clear that any general contractor that has a contract with a value of $100,000 or greater must file the notice of contract to preserve their right to file a lien against the property upon which the project, or against the project that is being built. And it's important whether or not the notice of contract is filed because it also affects the time period that subcontractors have to file liens. Those deadlines were also modified a few years ago under the law. So let's look at those for a minute. Let me say first, I'm sorry, next slide, please, on the notice of contract. I think it's important to remember what information goes into the notice itself. And if you are a subcontractor and a supplier, you can challenge the time period that you have to file a lien, that let's say you filed your lien late, if this notice of contract is not properly done, because then it's almost as if there was no notice of contract filed. The notice has to have the name and addresses of the owner and the contractor. It must contain a legal description of the property. So municipal addresses are not sufficient, just like they're not sufficient in a lien. It's got to be the full legal description. It has to say what the price of the work is and the method of payment, whether it's lump sum, cost plus GMP, what T&M, time and material basis. It's got to state that in the notice of contract, as well as how the payments are to be made, whether it's monthly, every 30 days upon submission of a pay application, or whether it's at certain phases, after the slab is poured, after all the mechanical electrical work has been completed. So that's all got to be set forth in the notice, and the notice has to be signed by the owner of the contractor. I recently had a client who had a signed contract, but they were concerned that they wouldn't be able to get the owner to sign a notice because time had gone by, they had not yet started the work, and it was a big company, the owner was. So they thought by the time they get to somebody that can actually sign the contract, it would delay commencement. So I said, that's okay. You don't need a notice. You can record the actual contract itself as long as you attach a legal description, because then it will satisfy all of these requirements. The reason we'd rather do a notice of contract is because most clerks of court charge by the page. So notice of contract is usually just one page, maybe two. If you have a bond, you got to attach it to the notice to record it, you know, in the mortgage records. And so the cost is a lot less than if you record a 40 or 50 page construction contract. Next slide, please. Okay, let's get into some of the deadlines now. For the Private Works Act, assuming that the contractor filed the notice of contract timely as it was required to do, then that general contractor has 60 days from recordation of the acceptance of the project in which to file its lien. Remember, it was the benefit of recording a notice of contract for a general contractor is twofold. First, they preserve their lien rights, and secondly, it shortens the time period by which a subcontractor is required to file its lien. And the reason that's important is because oftentimes general contractors in their prime contract with the owner says that they have to provide a clear L&P certificate to the owner showing that no subs or suppliers have filed liens, and then they can bill their final payment or they can bill for retainage. So the shorter that time period is, the quicker they're going to get paid from the owner. Now, in a situation where the notice of contract was filed, but no notice of termination was ever filed, then a general contractor has 7 months from the substantial completion or abandonment of the work to file its liens, and the subs and suppliers still have 60 days to file them. And what happens here is sometimes, let's say work just stops, the owner is going to try to go get more money, and it just sits there. Under the old law, if a notice of contract was filed and the acceptance was not recorded, then the time period never started to run by which a lien had to be filed. So to try to put some finality to that, the law was changed a few years ago to put this provision in. And I also forgot to mention that if the notice of termination is not filed, subs and suppliers get 6 months. So the owners, the general's got 7 months, and the sub and supplier has 6 months. Now, where the notice of contract's not filed, remember the general has no lien rights, the subs and suppliers have 60 days from actual substantial completion in which to record, or in termination. So in other words, when there's no more work being done, it's obvious, they have to, I don't know if obvious is the right word, but they have 60 days instead of 30 by which to record their lien. Remember, the important part when you do this lien on a private project is you've got to have a legal description. That's why generally you just look to the notice of contract. There's a legal description attached to that notice, then you just copy that legal description into your lien. On a public job, it's not required to have a legal description because generally the projects are by contract number or project number. It's because you're not liening the property itself. So that's why on we call them statement of claims as opposed to liens. On a public job, you don't have to have the legal description. You do have to have some reference to the general contract. So when the mortgage office is running what we call the lien and privilege certificate at the end of the job, you want them to be able to find that you filed the statement of claim against this particular public project. All right, next slide. Let's talk a little bit briefly about lien waivers. The reason I thought it's important to talk about lien waivers is, and for those of you that are not certain, generally on most projects, when you submit a payment application, if let's say you're a subcontractor and you submit it to the general contractor to include in its application to the owner, a lien waiver is required. It may be called a release, it may be called a waiver of liens, but generally what the document is trying to do is say that upon payment, you waive any right you have to lien this project. And it's a couple of different versions of this document. Some may, let's say, waive all the rights to the prior payment, which is the standard one, and that's one that I recommend. So in other words, when you submit pay application number 3, the lien waiver that's attached to that will say that you've been paid all amounts owed through pay application number 2. with the exception of retainage, or if you have claims or something. And the reason why that one makes more sense, that version, is because the general's not going to pay you until they get paid by the owner in most situations. So when he's submitting pay app number 3, he's already been paid for pay app number 1. He's already paid you for pay app number 2. He's already paid you for pay app number 2, but obviously he hasn't paid you for pay application number 3 because they're going to use that money when they get it from the owner to pay you. So what you want to look at is a couple of different things on these waivers. You want to look at, through what date am I releasing all of my claims? Am I releasing my claims to the date of the one I'm signing, which is the one I haven't been paid for yet? All right. If that's the case, you want to make sure it's either called a conditional waiver, or there's language in that waiver form that says, upon receipt of payment in the amount of $5,000, I hereby waive and release all of my claims, liens, et cetera, et cetera. So that waiver is only valid if you get the payment. All right. Some people even do what they call conditional with the current pay application and unconditional after you get the payment. So they make you sign 2 different waivers. One is when you submit the pay application, which is conditional, and then when they give you that check, you exchange it for an unconditional. Generally, those type of requirements are because the lender is requiring them to do that, all right, or the owner is requiring the general contractor to do that. So it's important that you look at what is it that you're waiving exactly. Secondly, through what date are you doing that waiver? Is it through the previous pay application? Is it through today? Is it through some other date? You also want to look to make sure that if you have pending claims, let's say you assert a claim for a delay claim, that you're not in any way, and you gave the notice that you're required to give under your contract, you just haven't, figured out the total amount of your damages, that you haven't quantified the damages. You want to make sure that you're not signing a waiver that's releasing all your claims through today, because 6 months from now, when you file suit saying, okay, I'm owed all this money, somebody's going to pull out the lien waiver and say, oh, no, you waived those claims 6 months ago when you signed this waiver. Lots of times what we see is on lien waivers, they'll have you waive all claims or all liens except for retainage, which obviously they're going to withhold retainage from each of your pay applications, or the items identified below. And then you write down what type of claims are pending. And so they all know that, okay, well, they're waiving all of this, but they're going to, you may still be negotiating that. You may negotiate it 2 pay applications later and it's finished and it's not present when you get to the end of the job. You just want to make sure that you've properly preserved your claims. Now, if the waiver is just your right to file a lien, then it may not be problematic because you still have your claim. You're just not going to assert it in a lien. So those are the kind of things that you want to look at, whether it's conditional, unconditional. And generally, the final lien waiver is the one that at the very end of the job where you waive all of your rights on the job upon receipt of the final payment that's owed to you under the contract, which may include retainage. Next slide, please. Okay, bonding out liens. This is what, when you file a lien, what happens is a couple of different things. If you are a subcontractor and you file a lien, that can trigger default under the general contract with the owner, so under the prime contract. If you're the general contractor and you file a lien, that could also trigger default under the owner's lending agreement with their bank, which obviously causes a problem for them. Same thing, even if you lien, if you're a subcontractor, this could also trigger default under the lending agreements with the bank. So it catches the owner's attention, and we're talking about in a private situation. So what happens is the owner says to the general, hey, I got this lien, I'm not going to release payment to you until you do something with the subcontractor lien. So either the general pays you what he's owed you, he gets an agreement with you that you'll agree to release it because you still have time to maybe refile it later, or they'll go ahead and bond it out. And what bonding out a lien means that they substitute security for 125% of your lien. So if you file a lien for $100, then they're going to file a release of lien bond for $125. And what that release of lien bond does is it tells the clerk of court it is okay to cancel this lien even though the claimant hasn't authorized a cancellation. because I now have security in place to protect, theoretically, the lien claimant and to protect the clerk of court because they canceled your lien without your permission. So what happens later is when you go to sue to collect on that money, you can now sue whoever that surety company is that is the release of lien bond surety. If there was an original payment bond, you can sue the payment bond surety as well as the release of lien bond surety. Oftentimes it's one and the same. Now, what you have to watch out for is if you file a lien in the wrong, let's say in the wrong parish, or you file it too late, then someone will send you a letter that says you've improperly filed this lien and you have 10 days to cancel it. If in fact it's improperly filed and you fail to cancel it voluntarily within 10 days, then they can bring an action against you for an improperly filed lien. And you'd be responsible for whatever damages were caused to them because you refused to take this lien off, as well as the attorney's fees that they've incurred in having to then take off the, go to court, get a judge to order you to cancel that lien. Next slide. All right, let's talk a little bit now about the filing of the suit. Basically what you're doing is you have a lien that's been filed. It's a properly filed lien. Time-wise, it was fine. What you're doing now is you're suing to enforce that lien. Remember, on a public job, what we're doing is we're now suing the general contractor and the bonding company because the owner, you got no claim against the state of Louisiana. You have no lien on that property, but what you've done is you've secured your claim against the bonding company. You just have to now go and prove it. You have to prove that wherever your contract was, whatever you furnished, you gave the proper notices and whatever you're due. On a private job, what you're trying to do is you're trying to enforce that lien such that it becomes a judgment, and then you have a cloud on the title of the owner because now you're in line to basically execute on that judgment against that piece of property, assuming that's what you want to do. So when you file suit, basically you're filing one to enforce the lien and have it recognized, and secondly, you're also filing for breach of contract because you may have additional remedies such as attorney's fees and interest and things that you're owed, but you couldn't include it in the lien. For example, the generally on liens, what's covered is what you incorporate into the project. So let's say that the transport's not covered in the lien, but you're entitled to get it under your contract. So that's why we normally see the suit is for breach of contract and to enforce a lien. So the breach of contract action is against the immediate party above you. Let's say you're a sub, so you're suing the general contractor. You're enforcing the lien on the property that belongs to the owner. Then there's also things like prompt pay violation. Under the law, the general contractor is supposed to pay its subcontractors within 15 days of when it receives money from the owner for amounts due. And if, quote, the phrase in the statute is, if without reasonable cause, the contractor fails to do that and pay you that money that's owed to you, then you have a claim for attorney's fees and interest of 0.5% for 15 days or up to 15%. Legal interest, I haven't looked lately, but it's usually like 4 or 5% a year. So obviously the prompt pay interest is much higher than the normal legal and judicial interest that you can recover. So, but it's the reasonable cause. So if there was an issue with your work or there's an issue under the contract or they can set off against a different project, then they may not be in violation of that statute. There's also prompt pay violation statutes against public bodies. They're also required to pay you, the general, within a certain amount of time, progress payments, as well as final payment. And if the public body doesn't pay the general, well, without reasonable cause within those time periods, then the contractor is also entitled to additional interest, attorney's fees, and those type of damages. Last thing that's really, really important, when you file suit on a private project, you need to file what's called the notice of lis pendens. And the reason you need to do that is because the notice of lis pendens tells somebody searching the title, going through the mortgage records, they're doing a title search, they're going to sell this piece of property, and they see that a lien was filed. And they say, oh, look, that lien was filed 2 years ago. Nothing's happened. So we can disregard that lien. We know it's not valid. It's not going to hold up the sale. We don't have to hold money back from the sale to pay off this lien claimant. But if you file a notice of lis pendens, which just means, you know, litigation is pending, then it tells the person doing the title search, wait, there's a lawsuit that's been filed on this lien. So now we know, oh no, if we're going to close on this sale, we're going to have to do something with that claim. We're either going to have to escrow money for that claim, we're going to have to pay that claimant. You know, we're not going to be able to sell this property with the lien on it because the suit's been filed timely on that lien. Next slide, please. Now, the time period to file the suit on the Public Works Act, remember, you don't have to worry about the notice of lis pendens so much there because you're not creating a cloud on the title of the property. You have 1 year from the acceptance of the default notice of termination to file your suit on your statement of claim. It's not from when the lien, you file the lien, it's from when the project was recorded. So it's important to, because it's the Private Works Act is a different deadline. And that's the next slide, please. Under the private works, it's 1 year from when you actually file the lien. So it's very important to remember that because it's if you miss the deadline, it's a problem. So we always in our office when we file a lien for a client, we always docket it 11 months before, so we remember what the 1 year deadline is going to be to file suit. If we haven't, you don't have to wait the year. It's just that's the outside date that you have to file that suit. And if you don't file it by that deadline, then there goes your lien. They can sell the property. They don't have to worry about your lien because it's really no longer valid on that piece of property. So that's basically it. So the question to what do you do after you record your lien, it's really the next step is file suit. But I always say it's important that when you record the lien, you send the notice to the owner of the lien. In fact, it's required in the Public Works Act because you want to give people notice that you're doing this because that may exert pressure on either the owner or the general contractor to get your claim resolved before you ever have to get to litigation. And for attorney's fees, because I know that's the question people are always most interested in, is if it's not in your contract, then generally the law is, unless it's allowed by statute or contract, you don't get attorney's fees. But there are a couple of statutes that allow for attorney's fees in the context of subcontractors or suppliers. For example, if you file a lien and you recover 100% of your lien and there's a surety company involved, then you get interest and fees, but you have to recover 100% of it. Under the prompt pay statute, you get attorney's fees. Under the Public Works Act, if you're the general contractor and the public entity has not paid you as required under the statute within those time periods, you also get interest and attorney's fees. So that's all I have for this today. If anybody has any questions.
Well, thank you so much for all those clarifications and nuances. There's so many different nuances, especially in the state of Louisiana, I feel like. So thank you so much for getting some of those clarified for us. We do have a question that has come through. It says, if I missed the deadline to send the preliminary notice, can I still file a lien? Are there any exceptions?
Yeah, it depends on who you are. In other words, if you are a lessor of equipment, then yeah, you're probably out of luck. If you are a subcontractor, someone, then you're probably okay. It just depends on who you are. And let me just say this on, for example, a lessor of equipment, the deadline starts each month again from the end of the month. In other words, I think it's 70 days from the last day of the month to send the notice. So let's say, you know, they didn't pay you for 8 months. You may be out of luck on the first 3. You sent notices, but maybe they were too late for the first 3. But you still have valid claim for the time in which the notice is timely, if that makes sense.
Okay, all right, thank you so much. And then the other question that came through, it says, is there a priority when there are multiple liens on the same project? What if there is a existing mortgage?
Yeah, okay, if there's an existing mortgage, the mortgage is going to rank. But as far as the liens that are filed by either subcontractors or suppliers, they all rank equally. So in other words, it's not a matter of you filed your lien first and you filed it a week before the landscaper filed his. No, those are all going to run the same. The only thing that's going to be ahead of you is going to be mortgages or anything that's recorded before the notice of contract starts. Now, if work started, for example, and then the mortgage gets recorded and then the notice of contract gets recorded, then all of those workers are going to prime the mortgage. But generally, banks always require what's called a no work affidavit. So the surveyor goes out there and says, no, the dirt hasn't been disturbed or there's no work done. So the bank records their mortgage. They're going to be first, all right? And if there's a second, you know. But once the work starts and once the lien period starts, everybody related to the project, they're going to rank the same. So whether you file it and somebody else files it, you know, the 45th day or whatever, they're all going to rank the same, and you basically share whatever money they're able to get.
Okay,
And
wonderful.
I was just gonna say, if, for example, you are, you know, there's a mortgage on the property, you file a lien, you get your judgment, you're going to execute on your judgment, it goes to auction. There's got to be enough bid in there to pay off the first mortgage before you get any of the proceeds.
Okay. All right. Wonderful. Okay. So that does seem to be the last question that has come through. If anybody does think of another question that wasn't addressed, please feel free to reach out. We'll be sure to answer any questions for you as soon as we are able to. All right, let's go to the next slide here. All right, here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Please remember each state has its own unique deadlines, documents, everything. So unfortunately, nothing is consistent, so please check it out so that way you can make sure that you are staying ahead of the game and knowing what you have to do and what's expected of you. All right, let's see here. All right, if you guys don't mind, give us a quick moment of your time. Give us a review on Google. We really appreciate any of the feedback that you're able to provide to us. All right, and with that, that is all we have for you guys today. Denise, thank you so much. You really are wonderful. Thank you, everyone who was able to attend. We hope to see you guys at our next webinar. I hope you all have a beautiful and wonderful sunny day. Thanks again.